If the court please, is the reserve time, is that in addition to the 15 minutes or is that taken out of the 15 minutes?
Out of the 15.
Okay. I'll reserve a minute.
1 minute?
Yes, sir. I don't know that I'll need it.
All right.
But just to give me a safety valve.
All right.
Yeah, my name's John Miles. I'm from Union City in Obion County. I represent Brayleigh, Canada, and we appealed a custody ruling from the Lake County Juvenile Court, and I raised a number of issues. The first three issues, if your honors please, really just sort of factor into the fourth issue at some level. The first two issues, the first one had to do with a photograph that the court considered. It's obvious he considered it when you read his opinion. The second issue was a video that he referred to in his opinion, which I take it he considered in rendering his opinion. The third issue was whether or not it was proper for him to consider circumstances surrounding the entry of the initial permanent parenting plan that the parties entered into. And then the fourth issue, if your honors please, was that I feel that in this case that it was error for the court not to reverse the custody and award custody to Mr. Canada because it was illogical result. It was flawed reasoning and primarily, I would say, a clearly erroneous assessment of the evidence. What I would like to do is a few housekeeping things. On page 9 of my brief, seems like no matter how many times you reread these, you find little errors. There in the middle of the page, it says the court held in the affirmative on the threshold issue based upon the preponderance of the evidence and then proceeded to make a determination of whether or not a change of custody. It says or, that should be of. I mean, it says of, it should be or. And there are a couple of others. On page 37, I used the word condition. It should have been conditions. And on page 39, I used the word had. It should be hard. I just want to make mention of that. But what I would like to do initially is respond to some of the things that Ms. Sipes raised in her responsive brief. Firstly, on page 11 of her brief, she states, note the appellant would object to any matter related to the father's October 2020 emergency custody petition as it's not a part of the technical record. Well, that shook me a little bit because Ms. Sipes and I entered into an agreed order to supplement the record with that information. And it's in volume 5 of the technical record on page, beginning at page 10 and page 11. I mean, she and I made the agreement. There's the written order. It's in the record. So I don't know why she has that statement in her brief. If you look at page 20 of her brief and also again on page 24, she states on both those pages that the video, this is the video that was apparently displayed to Mr. Canada as he testified by Ms. Swift's attorney. It says that it was reviewed by Father's Counsel. Well, I was Father's Counsel. I did not review the video. I never saw the video. I never saw the photograph that I'm also objecting that the court relied on, and neither of them were offered into evidence. I just want to make it clear there's nothing in the record that indicates that I was ever given an opportunity to review it or that I did review it, and I just want to make clear to the court that I did not. Not a big point, but on page 6, Ms. Sipes was critical of Mr. Canada for what she says was only offering her client 4 days a month in visitation in his proposed parenting plan. But I would point out that that's exactly how much time her client offered Mr. Canada in her proposed parenting plan. And actually, Mr. Canada offered 85 days a year, which is not quite twice that amount. It's about 7 days a month. But he also testified that he was open to supplement that.
Mr. Miles, before you go any farther, let me ask you a question. Back on your photo and video, both parties discussed this photo and video quite a bit in their briefs. So you say you never saw either one of those?
No, ma'am.
So did the judge see those things?
I think the judge may have seen it. I think it's clear that defense counsel handed his phone to him or something. It apparently was on a phone, but it wasn't on a jump drive. And the photograph, I don't know what the photograph was on. It wasn't a hard copy. I never saw either.
So you think that potentially the judge saw both the photo and the video off of a phone?
I think so, because he references them in his order. And of course, I think about use before a jury, but I mean, this is a judge trial. And my experience, and I do a lot of bench trials, is that, you know, I've heard many judges say, if you want that considered, you better offer it into evidence. It was never offered into evidence. In fact, Mr. Hamlin, with regard to the video, just said, well, the judge can do whatever he wants to do. Because I asked, are you going to offer that?
So I'm having a hard time here trying to understand exactly how all this went on. And so the judge, you had a witness on the stand, or the other side had a witness?
The witness was my client, Mr.
All right.
Canada.
So you had a witness on the stand that was your client, and your client was testifying about two objects that would be a video and a photograph of whatever it was. And during the course of your client's examination, opposing counsel saw these things.
Oh, I'm
Is that
sorry.
right?
Excuse me. He was being cross-examined.
I'm sorry.
by
During the course
opposing
of the
counsel.
cross-examination.
And it was opposing counsel who was using these.
Opposing counsel saw these. And so the judge ends up seeing these, but you never saw them.
No, ma'am.
So you didn't see them on redirect? I mean, you didn't?
They were never offered. They were never made part of the record. Why would I do that? I mean, if he's not going to offer them, I don't have any question about when we mentioned much. Seems to me it's a nullity. But
Was there any objection to the court reviewing
I
it,
didn't, Your Honor.
or that they be considered?
Again, I thought about the analogy of use before a jury, but it was not a jury trial. I think it's apparent the judge looked at them both, but they were never offered into evidence. And as I said, with regard to the video, at one point in the trial, I said, Your Honor, is he going to offer that? Because I'm waiting for an offer for me to make an objection, if there is one. But I don't know why I need to object if he's not going to offer it into evidence.
For fear of waiver?
Yes, sir, I understand. I just think with a bench trial, there's less danger in a court or a fact finder considering something that's outside the record.
You said the court mentioned it in its order. Did you file anything to ask the court to reconsider it since it wasn't entered into evidence?
No, sir. It's a bench trial. No, sir. I didn't. Let me move quickly if I can. Ms. Sipes points out that there wasn't a single witness that testified that a modification of the parenting plan making the father primary residential parent would serve the best interest of the child. Well, of course, that's not a proper question for anybody but a party or an expert. I don't call some witness who's a neighbor or a friend or somebody else and say, do you think it's in the child's best interest? I mean, that's a question for the court. So I just want to make that clear. I mean, I would never ask a question like that of a lay witness. Ms. Sipes also discussed that the father testified. Well, because of time, I'm going to skip through some of this. I do want to point out a few things. If we go to page 10 of Ms. Sipes' brief, on the very first sentence, she states that interpersonal conflict overflowed to the minor child by virtue of the father's generation of an intent to enter into the permanent parenting plan. She cites the record. There's absolutely nothing in the record to support that allegation. Also on page 10, the last two sentences of the first full paragraph, she states, so long as the parties peacefully cohabitated, the minor's child presence shielded the father from any fear. She makes an argument here and puts it in her statement of facts. There's nothing in the record to support that. She states that there's nothing in the record to show that the child's relationship with the mother's other daughter or the mother's family were not in the child's best interest. Well, that's because there's nothing in the record about the child's relationship with any of them, about her daughter or the mother's family. There is some reference to the mother about nurturing the child, but that's about the extent of it. Ms. Sipes on page 13 and 14 says, I'm interjecting my standards. I'm not interjecting my standards. The standards are the factors of TCA 366106. Those are the standards, and they have to be viewed, I would think, as we weigh things under just common, an evaluation that we use our experiences of common decency. But there have to be some societal norms that we can use. I attempted, beginning on page 34 of my brief, I went into as much detail as I could, an examination of all the factors in the statute based upon the evidence and the law. Because of my time limitation, I want to get to this one point because I think it's the most important point I can make. Ms. Sipes makes over and over this point, well, there's nothing to show that this was having a bad effect on the child. I don't think we have to wait for the train wreck to happen before we know that it's coming. If you've reviewed the record in this matter, I mean, there's certain latent things that happen that our common sense tells us are going to do harm and are not in the best interest of raising a child. On the one hand, the father, he took the child to SeaWorld. He took the child to St. Louis, to the City Museum and Magic House. He took her to SeaWorld, took her to the Obion County Public Library, where she and her brother would play and check out books and read books. He testified that he's saving for their education, goes on a horse camp, trail riding, provides health insurance, expressed to the court his love for his daughter, wants to be a supportive and protective parent, wants the children to reach their full potential. He's remodeling a home for them, and testimony from some of the other witnesses, a very responsible young man. The mother of his other child gave him an A for co-parenting. His sister says, great father, does everything himself. On the other hand, Miss Swift, there are some bad things that happen in the world, and sometimes they are so bad that we don't want to look at them. We don't want, and just for some reason we just look away. She performed in a pornographic video, and she texts a neighbor, not a neighbor, but a family friend. So I covered it on page 34 of my brief. This. It's not a nice thing to read. I wish you would beat that bitch boy ass. Man, I never knew how much of a bitch he is. Been trying to make shit work out with him for so long. I'm tired of MF trying to make me feel like I ain't nobody because his entire life he has already been around nobody. I think that's all my time.
All right.
Good afternoon, Your Honors. My name is Andrea Sipes. I'm from the Jackson Bar, and I'm here for the appellee, Sakita Swift, today. Your Honors, The first three issues of this case are really simple. The first three issues are the photograph, the video, and then considering the facts surrounding the 2017 permanent parenting plan. The reason these three issues are so simple is because there was no objection at trial. As to the photograph, the father was questioned about these photographs and admitted during his examination that his wife took illicit photographs and had posted at least one illicit photograph on social media. That testimony was not objected to. If the judge was shown the photograph, which the transcript seems to indicate that he was, that also was not objected to. Same thing with the video. Mr. Canada was questioned about the video, and under examination, he gave testimony regarding what was encapsulated in that video. Again, there was no objection. The judge viewed the video. There was no objection. Same thing with issue 3, Your Honors. They object now to the court considering the facts surrounding the original parenting plan. However, at trial, there were no objections. And I don't mean to beat a dead horse, but I think we were all taught that if you don't object at trial, you have waived it for purposes of appeal. That leaves us with the 4th issue, which is the outcome is against the preponderance of the evidence and that the judge committed an abuse of discretion. Your Honors, the judge here found that there had been changes, then undertook to analyze all the statutory factors in 36-6106A, and then came to the conclusion after weighing the factors that the child was not affected in a meaningful way. It is not just enough that things have changed. It's not enough that things are different. This is not a parental fitness evaluation. This is not an initial parenting plan. This is a modification of a parenting plan. And to modify the parenting plan, you need to show that the child has been affected in a meaningful way. There was a lot of testimony about the parents in this case, but not a lot of testimony about the child or her being negatively impacted by anything that took place. The father wants to complain about the mother making a pornographic video. I would point out that she made that video before the child was born. They want to make issue of the mother making a trip to Beale Street and going to Florida. There is no proof that that child was with her, exposed to anything, and the last time I checked, parents are still allowed to have lives outside of their children. Nobody's saying Mr. Canada is not a great father. Nobody's asserting that at all. But the child is doing well. There was no evidence to the contrary. Therefore, there was no basis to modify the permanent parenting plan in this cause.
Any questions? Thank you.
Thank you.
You have a minute if you want to take it.
The only point I would make is that I think that the trial court's decision was so far against the great weight of the evidence that it was an abuse of discretion. I mean, I know that's the question that's on each of your honors' minds. And I don't make that many trips up to the Court of Appeals, but yes, I'm saying in this case, it was.
All right, thank you. Counsel, thank you. We will get you an opinion as soon as we can. We appreciate your argument today. Thank you. May dismiss court.
All right.